Good morning, everyone. So, today we will have some basic knowledge about what is evidence law and what does Indian Evidence Act contains and teaches us. So, without wasting any time, let's start with it. Starting with the first question, which is the Indian Evidence Act was drafted by whom of the following? The options are A. Lord Macaulay, B. Sir James F. Stephen, C. Huxley, or D. Sir Henry Summer Maine? The correct answer to this question is option B, that is, the Indian Evidence Act was drafted by Sir James F. Stephen. The next question is the law of evidence consists of what? The options are A. Ordinary rules of reasoning, B. Legal rules of evidence, C. Rules of logic, or D. All of the above. The correct answer to this question is option B, that is, the law of evidence consists of legal rules of evidence. Basically, the law of evidence comes under the criminal law, which entails both IPC and CRPC. IPC, CRPC, and evidence makes the criminal law complete. That is why these three laws combined together makes a criminal journal. You can say criminal manual. So the law of evidence consists the basic rule of evidence on how as evidence can be collected and can be presented in a court, and who all are authorized for collecting and presenting of the evidence in the criminal law. So, having the basic idea of what is law of evidence, let's move on to the next question, which is the relevancy and the admissibility under the Indian Evidence Act are what type of concepts? The options are A. They are synonyms. B. Relevancy and admissibility are coextensive. C. They are neither synonyms nor coextensive. Or D. They are synonym and coextensive both. The correct answer to this question is option C, that is, the relevancy and the admissibility are neither synonymous nor coextensive, and they are different in altogether as a concept. Let's move on to the next question, which is self-regarding statements are what type of statements? The options are A. These statements can be self-serving statements. B. Self-regarding statements can be self-harming statements. C. These statements can be self-serving or self-harming. Or D. None of the above. The correct answer to this question is option C. That is, self-regarding statements can be self-serving or self-harming in their nature. Moving on to the next question, that is, what is correct as regards the admissibility of self-regarding statements? The options are A. Self-harming statements is admissible, but self-serving statement is not generally admissible. Option B. Self-serving statement is admissible, but a self-harming statement is not generally admissible. Option C. Self-serving and self-harming statements both are generally admissible. And option D, self-serving and self-harming statements both are generally inadmissible. The correct option regarding this question is option A, that is, self-harming statement is admissible but self-serving statement is not generally admissible is correct as regard to the admissibility of self-regarding statements. Moving on to the next question, which is under the law of evidence, as a general rule, select the correct option among the following. The options are A. Opinion on a matter of fact is relevant but not on a matter of law. B. Opinion on a matter of law is relevant but not on a matter of fact. C. Opinion on a matter of fact and law both are relevant. And option D, opinion whether on a matter of fact or law is irrelevant. The correct answer to this question is option D. That is, under the law of evidence, the general rule is that the opinion, whether on a matter of fact or law, is irrelevant. This is because or that the opinion in any thing is irrelevant until and unless it is backed by solid fact or solid proof. An opinion regarding something can be different with the perception of different person, and it does not have a credible value in the legal field. That is why the opinion, whether on a matter of fact or law, is irrelevant in the law of evidence. The next question is, Indian Evidence Act applies to which of the following? The options are A. Proceeding before tribunals, B. Proceedings before the arbitrator, C. Judicial proceedings in court, or D. All of the above. The correct answer to this question is option C, that is, Indian Evidence Act applies to judicial proceedings in court only. This is because every tribunal and every arbitration proceeding have their own set of procedure, as well as the procedure of taking or admitting any evidence. But the judicial proceedings in court act on the basis of the law that is given in Indian Evidence Act. Moving on to the next question, that is, law of evidence is dash. Select the option from the following. The options are A. Lex Telenis, B. Lex Fori, C. Lex Loci Solutionis, or D. Lex Status. The correct answer to this question is option B, that is, law of evidence is Lex Fori. So let us understand what is Lex Fori. Now let's understand the concept of Lex Fori. It is a choice of rule of law. If applicable, it provides that the law of the jurisdiction or the venue in which a legal action is brought applies. When a court decides that it should, by the reason of the principle of conflict of law, resolve a given legal dispute by reference to the laws of another jurisdiction, the lex causae or the lex fori still governs procedural matters. The next question is, the law of evidence is dash. Correct. Select the correct options among the following. The options are a substantive law, B, an adjective law, C, both A and B, D, neither A nor B. The correct answer to this question is option B. That is, a law of evidence is an adjective law. Moving on to the next question, that is, fact can be dash. Fill in the blanks with the options given below. The options are A, physical facts, B, psychological facts, C, physical as well as psychological facts, or D, only physical facts and not psychological facts. The correct option to this question is option C, that is, physical as well as psychological fact. That means to say, facts in the Evidence Act can be physical as well as psychological fact. Let's move on to the next question, which is, under the Evidence Act, fact means what? The options are A, factum probandum, B, factum probans, C, both factum probandum and factum probans, or D, none of the above. The correct answer to this question is option C, that is, under the Evidence Act, fact means both factium probandum as well as factum probans. Now let us understand the meaning of both these terms. Understand the concept of factum probandum and factum probis. The factum probandum is a legal term which means the principal fact that has to be proved in a court of law. This means that it is a fact under which the whole legal procedure revolves, and that this fact has to be proved in a court of law to establish a given fact or an evidence. Factum probis, on the other hand, is a legal term which means evidentiary fact from which the principal fact follows immediately or by inference. So, after understanding the meaning of both the terms, let's move on to the next question, that is, fact and issue means what? The options are A. Fact, existence or non-existence of which is admitted by the parties. B. Fact, existence or non-existence of which is disputed by the parties. C. Fact, existence or non-existence of which is not disputed by the parties. Or option D, that is all of the above. The correct answer to this question is option B, that is, fact and issue means the fact whose existence or non-existence of which is disputed by the parties. Normally, fact and issue means the fact on which the argument has to be done, or the fact on which the court has to give its judgment whether it exists or it is non-existent, or under which the parties on both the side try to prove or disprove that fact. Let's move on to the next question, which is evidence under the Indian Evidence Act means and includes which of the following? The options are A. Verbal evidence, B. Documentary evidence, C. Verbal and documentary evidence both, or D. Verbal evidence based on documents only. The correct answer to this question is option C, that is, evidence under the Evidence Act means and include both, that is, verbal as well as documentary evidence. The next question is based on a proposition, which is proposition under the Evidence Act are affidavit is an evidence. A. First, affidavit is an evidence. Second, everything produced before the court for inspection is evidence. Third, everything of which judicial notice can be taken is evidence. Or fourth, written statement of an accused is evidence. Now, the question is which of the following is true in respect of the opposite propositions? The options are A. First, second, third, and fourth, all statements are correct. B. First, second, and third statements are correct, but fourth statement is incorrect. C. First, second, and fourth statement are correct, but third is incorrect. D. First, second, and fourth are incorrect, but third is correct. E. First and second statement are correct, but third and fourth are incorrect. Or F. Only first statement is correct, but second, third, and fourth are correct. The correct answer to this question is option D, that is, the statement first, second, and fourth are incorrect, but third statement is correct. Moving on to the last question for the day, that is, proof of a fact depends on which of the following? The options are A. Accuracy of the statement and not upon the probability of its existence. B. Not upon the accuracy of statement but upon the probability of its existence. C. Artificial probative value assigned to a fact. Or option D. Rigid mathematical demonstration. The correct answer to this question is option B, that is, proof of fact depends on not upon the accuracy of the statement but upon the probability of its existence. This means to say that the fact is proved if it can be practically performed in a given scenario or in a given situation, and it does not depend on the accuracy by which it can be performed, but the probability that it can be performed in a given circumstances or a situation. This was the end of our first presentation. Hope you all liked it and hope this presentation or video was able to teach you something about the civil procedure code. Thank you for watching it. Thank you.